The U.S. Department of State's Visa Bulletin, an overview. The Visa Bulletin and why it matters. The U.S. Department of State's Visa Bulletin is a monthly bulletin released to show the availability of family-based visas and employment-based visas in the United States. Once an applicant has an approved visa petition, such as an approved I-130 or I-140, the Visa Bulletin indicates when that visa will become usable for adjustment to permanent residence or entry into the United States. There are limits on how many visas can be issued each year. Therefore, even with an approved petition, an applicant may not be eligible to apply for status immediately. How does the Visa Bulletin work? On this slide, you can see the Visa Bulletin for May of 2023 for all family-based visas. On the far left, it has the family-based visa category type. This is the relationship between the petitioner and the beneficiary. So, if a petitioner is a U.S. citizen and they file for an unmarried son or daughter, that would be category F1. If they're a lawful permanent resident and they file for their spouse or children, that would be category F2A. If they're a lawful permanent resident and they file for an unmarried son or daughter, that's category F2B. And if they're a U.S. citizen and they file for a married son or daughter, that's F3. And finally, if they're a U.S. citizen and they file for a sibling, that's category F4. The date on which a petition is filed is generally referred to as the priority date. That is the date that controls to determine when a visa is available for that particular beneficiary. So for example, if a U.S. citizen were to file a petition for a sibling who is a citizen of Mexico, you'd refer to the bottom, F4, you'd go over to the Mexico column, and you can see the date listed there as April 1st, 2001. So what does that mean? That means that all petitions filed on or before that date currently have a visa available. Petitions filed after that date do not have a visa available and will have to continue waiting. Utilizing a different example, if a U.S. citizen were to file in category F1 and the beneficiary was a citizen of China, you would refer over to the China column in F1, and that date is currently January 1st, 2017. If that petitioner filed a petition today, that means they would be waiting approximately 6 years until the visa becomes available, assuming that petitions and visa availability remains largely constant. That's because each month the Visa Bulletin will get closer to the present date. So next month it'll progress further towards the present, and so on and so forth. Assuming it continues at the same pace, a petitioner who files today can expect to have a visa current for their category in approximately 6 years. The C's listed next to category F2A refer to the visa being current. That means that a lawful permanent resident filing for a spouse or child does not have to wait. The visa is immediately available, and there's no need to wait any number of months. That brings us to special immigrant juvenile visas, the focus of this presentation. On this slide, you can see the Visa Bulletin for employment-based visas. Special immigrant juvenile visas are dependent on the fourth category. That means that if an individual files a special immigrant juvenile visa and they are a citizen of one of the countries listed, they would refer to that date to determine when their visa will become available. That means if a petitioner files a special immigrant juvenile visa petition today and they are a citizen of Mexico, they would be waiting approximately 5 years. Or more accurately, about 4.5 years, because they would be referring to the Mexico column and going down to the fourth level, which is bolded, and they would see that it's October 1st, 2018, meaning all petitioners who filed a special immigrant juvenile visa on or before that date have a visa available. All petitioners filing now are waiting, as I said, approximately 5 years until their visa becomes available. On that date, they can then adjust status to permanent residence, or they can enter the United States as a permanent resident after going through the application process. Who are we? Serene Manzar and Ryan Eldred, immigration, family law, and probate attorneys in Sacramento, California.